Okay, we're back. Right. So we covered off 1.4. Next bit of 1.4 is what mitigation is. That's factors presented by the defendants asking for leniency. You also need to know the difference between previous convictions and offences taken into consideration. So, offences taken into consideration are offences the defendant admits, although he/she may not have been charged with them. By admitting them, the defendant removes the possibility of being prosecuted for them in future, providing the opportunity for a fresh start. 1.5. The most criminal cases are, well, you need to know that most criminal cases are dealt with by magistrates, but that some more serious cases are dealt with by the Crown Courts. Also need to know the limits on the powers of magistrates to sentence defendants to jail terms. So no maximum powers of 6 months for a single offence, or up to 12 for more than one offence if they decide that the jail term should run consecutively. That is one after the other. Concurrent is where the defendant is sentenced overall, only for the length of the longest sentence imposed. More definitions which we'll come back to, but I've covered off a couple. Suspended sentence, concurrent sentence, consecutive sentence, and definitions of absolute discharge, conditional discharge, and community order, which can also be called community sentence or community punishment. 1.6. That the Crown Court functions include trials and sentencing, and hearing appeals from magistrates' courts against verdict or sentence. So that's as it is. What an indictment is, that is the document used at a Crown Court to record the charges. The roles of juries in criminal cases and at judges' sentence. So juries decide if each charge is proved, judges rule on the law, and sentence convicted defenders. Jury consists of 12 people, aged between the age of 18 and 70, although the government had put plans that raise the upper limit to 75 in 2014, which hasn't been put through yet. They're selected randomly from the electoral rolls, and jurors are sent a summons to appear. You need to know the acceptable ratios in jury votes on criminal verdicts, the best practice in reporting majority verdicts. So if a jury has deliberated for at least 2 hours 10 minutes without reaching a verdict, the judge can recall to open court and inform that they are willing to permit a majority verdict. For juries of 12, that's 11-1 or 10-2 ratios. If it's a reduced jury, that's 10-1 or 9-1. Media should make specific references to a majority verdict in their reporting of a conviction, but not for an acquittal. A hung jury is one that can't reach a verdict. Also need to know that the Crown Court practice is that the earliest stage at which a judge can accept a majority verdict is when the jury has been deliberating for 2 hours 10 minutes, which I covered off. 1.7. Types of judges, including district judges. This is a long one. We've got magistrates who have a title of the Justice of the Peace. They are lay magistrates and are trained and paid expenses. If they try a criminal case, there must be 2 of them, known as a summary trial, advised on law by a justice clerk or legal advisors who sit in front of the magistrates in court. We then have a district judge. There are 140 professional salaried magistrates appointed after at least 5 years' experience as a lawyer or legal executive. They can trial cases on their own. High Court judges, referred to as Mr. or Mrs. Justice Smith, they wear red robes for criminal cases. Only they can try the most serious offences. Circuit judges, referred to as Judge John / Mary Smith, are barristers of at least 10 years standing or solicitors who have been recorders. So recorders are part-time judges, barristers or solicitors who have held right of audience, that is the right to represent clients, at Crown Court. They are usually referred to as the recorder, Mrs. Mary Smith. Page 140 of the Nays gives the roles for civil courts. So, on to the next bit. That the High Court hears appeals from magistrates' courts and Crown Courts on rulings on decisions on law made by those courts and conducts judicial reviews. A judicial review is a hearing which can consider other types of challenge to decisions made by magistrates. The media can use judicial reviews to challenge discretionary reporting restrictions imposed by magistrates. You need to know that the Court of Appeal in criminal cases hears appeals from the Crown Courts in which it can uphold or quash convictions, and may order there to be a retrial by jury, that is, that it can also hear appeals against the severity of a sentence imposed by a Crown Court. So the Court of Appeal is normally heard by 3 judges. Appeals beyond the Court of Appeal go to the Supreme Court. So that's section 1. Now on to part 2, which has got a catchy title: Automatic Restrictions on Media Reports of Preliminary Hearings in Indictable Only and Either Way Cases at Magistrates' Courts, and on media reports of cases at youth courts which retain the potential for jury trial. Court procedure in such hearings. So 2.1, you need to know the distinction between summary, either way, and indictable only offences in the magistrate's adult court. Indictable only are the most serious crimes, punishable by the longest prison terms, processed initially by magistrates but progress quickly to Crown Court. Either way include offences such as theft, sexual assault, can be dealt with by either the Crown or Magistrates' Court, hence the term. Magistrates will hear the outline and can decide whether to send to the Crown Court. Defendant also has a legal right to choose trial by jury at Crown Court. Procedure in either way cases, that is, what happens in the allocation procedure in magistrates' courts, including the difference between indication of plea and formal plea. So, my notes here. The first hearing at a magistrates' court, the defendant is asked how they intend to plea. If defendants plead guilty, this is automatically treated as a formal plea of guilty, convicting them of that offence. Magistrates will consider details of the offence and previous convictions to determine whether they can sentence or if the case should be committed for sentence, i.e. sent to Crown Court. If the defendant pleads not guilty, magistrates decide if they should be offered the option of a summary trial. The allocation is based on whether the magistrates consider they have sufficient power to punish the defendant. To do that, they will be given details of the offence so they can assess the seriousness of the allegation. If the magistrates decide they can try the case, they accept jurisdiction. If not, they will send the trial to Crown Court. When at Crown Court, the defendant could also be asked if they want that or jury trial if the magistrates decide they can accept jurisdiction. At the summary or jury trial, the defendant will be asked to submit a formal plea. So there are also 2 types of either way cases that are just sent: serious or complex fraud cases, or cases which alleged offending in sexual or violent is sexual or violent and a child is due to be a witness. There's a good diagram on now, so let's see if we can get that. Page 75. This one here, not that you can see it much, but that is the route for court matters. Okay. We need to know the meanings of sending for trial and committal for sentence. I'll cover that in a bit above, so go back to that if you missed it. 2.2. The scope of the restrictions in Section 52A of the Crime and Disorder Act 1998 on the reporting of preliminary proceedings at magistrates' courts, including bail applications, allocation procedure, and sending for trial procedure, in cases which had or have potential for jury trial when such restrictions apply, including when they cease to apply. So basically, remember, these are automatic restrictions. You also need to know that it's safe to report a basic protestation of innocence, indication of not guilty plea, and or that the defendant has chosen to be tried by a jury, and bland scene-setting material, even when these restrictions apply. It says read page 69, so let's find that. This is the scope of the Section 52A restrictions in the Crime and Disorder Act 1998. So, the Section 52A restrictions list categories of information from preliminary hearings at magistrates' courts which can be published. The list is expressed here in simplified format, with explanations in italics. The name of the court, for example, Doncaster Magistrates' Court, not too far away, and the magistrate's name, or names. the name, age, home address and occupation of the accused. In the case of an accused charged with a serious or complex fraud, any relevant business information. The charges in full summarised. The names of counsel and solicitors engaged in the proceedings. If proceedings are adjourned, the date and place to which they are adjourned. Arrangements as to bail, that is whether bail was granted, and if it was, any bail conditions and surety arrangement. If bail is refused, the usual approach is that the media organisations do not report why the prosecution opposed bail or the magistrate's reason for refusing it, as such information might be prejudicial, but it would be safe to report that someone was remanded in custody for his or her own protection. Whether legal aid was authorised to pay for the defendants to be represented by a lawyer. The fact that reporting restrictions are enforced can be reported. The 1998 Act does not specify this, but it cannot be prejudicial to publish this fact. Okay, so we also need to know the contempt danger in disclosing any previous conditions aired in court during a preliminary hearing, even when the Section 52A restrictions do not apply, that the restrictions do not apply to reporting of the actual trial. So there we go. Previous convictions should be obvious. People are tried on the charge, not what they've done previously. Okay. So 2.3. That the Section 52A restrictions apply to media reports of preliminary proceedings in serious cases at youth court, that is, those retaining the potential of being tried at Crown Court, or which must be dealt with at a Crown Court, including those concerning murder, manslaughter, and certain other types of cases. It is worth noting Section 8C of the Magistrates Court Act 1980 put automatic reporting restrictions for pre-trial hearings of a case to be tried by a youth court. That the restrictions do not apply to the reporting of the actual trial. No exam question will ask candidates to list all the types of cases at youth court which can end up at Crown Court. So that's section 2. On to part 3. Contempt and related matters. 3.1. We need to know the strict liability rule of the Contempt of Court Act 1981, and that the purpose of this part of the Act is to protect the fairness of any trial in the case, when criminal and civil cases become and cease to be active, the type of material which is published, if published, could breach the Act and why. So, the type of information which can be published without breaching the Act and why. We've got quite a few pages here in it, so let's have a look what we've got. So, 234. When are criminal proceedings active? The strict liability rule applies only if proceedings are active, which is when a person is arrested, an arrest warrant is issued, a summons is issued, a person is charged orally, or a document specifying the charge is served on the accused. When do criminal proceedings cease to be active? The arrested person is released without being charged, except when released on police bail. No arrest is made within 12 months of the issue of the arrest warrant. The case is discontinued. The defendant is acquitted or sentenced, or the defendant is found unfit to be tried or unfit to plead, or the court orders the charge to lie on file. Then we've got material that can be called substantial risk of serious prejudice or impediment. So, the 1981 Act does not define what creates a substantial risk or serious prejudice or impediment to an active case. Cases in which editors and media organisations have been convicted of contempt show that material which could be held to be contempt in active cases include references to a suspect or defendant's previous convictions, information suggesting he/she is dishonest or of bad character in other ways, any evidence seeming to link him/her directly to the crime of which he/she is suspected or accused, any other suggestion he/she is guilty. It also explains that it could also be contempt to publish a witness's detailed account of a relevant event after a case becomes active, a photo or footage or physical description of a suspect when visual identification of the alleged perpetrator is or is likely to be an issued because a police identity parade is to be held and or a witness is expected to testify at the trial on such identification. But that doesn't actually include helping police with inquiries. Right, voice is going. Oh, one more page. 241, what can be published? So basically, it's non-prejudicial basic information about the crime can be published. For example, the media can report that there was a robbery, where it took place, and that later someone was arrested. They should not report that the robber was later arrested, as this says the arrested person is guilty of the offence. Note that the Attorney General is concerned about frenzied interest in high-profile cases. We'll go with that. Basically, it's common ground you can cover. Where were we? Okay, you need to know what the fate factor is, and that it may not be enough to prevent liability for contempt for impediment. Fate factor refers to the recognition that the public will probably have forgotten detail in reports published in the early stages of a criminal case. For example, soon after the crime, by the time a jury is selected. Jurors are also told to put pre-trial publicity out of their minds. However, some material could be considered so striking it could still be considered to create a serious risk of serious prejudice or impediment. Also need to know that the 1981 Act covers inquests and when they are active, the contempt risk in archived material being accessible to the public on websites, and how the media should react to complaints that such material could or does not cause prejudice. Basically, an inquest becomes active when it opens, but special care should be taken when a jury is involved. 3.2. What risks exist, if any, of breaching the Act as regards publishing background features after a verdicts are reached in a Crown Court case, or publishing material relating to criminal cases pending appeal hearings in the Court of Appeal, or if the Court of Appeal orders there to be a retrial by jury. So when an appeal is lodged, the case becomes active again. But if an appeal is lodged against a Crown Court conviction, the media still have considerable freedom on what can be published, because an appeal will be heard by judges of the Court of Appeal, who are thought of as incorruptible. However, if the result of the appeal is to order a retrial, and a jury trial, there then becomes a risk in publishing details. 3.3. Who has the powers to initiate contempt proceedings under the 1981 Act? So I think this means in relation to publication, in which case this would only be a Crown Court or higher with the consent of the Attorney General. Currently, Attorney General is Jeremy Wright QC. 3.4. The Section 4 defence in the 1981 Act for the reports of court cases, including inquests. So Section 4 is a report of a court hearing held in public cannot be considered contempt if it is fair and accurate, it is published contemporaneously, love that word, and in good faith. 3.5. The grounds on which courts can make an order under Section 4.2 of the 1981 Act postponing publication of a report case, and the scope such order can have, examples of circumstances in which a court may make such an order. So a court can postpone reporting Section 4.2 where there is potential substantial risk of prejudice to the administration of justice in those proceedings, or in any other proceedings pending or imminent, and that the period of postponement may be as long as the court thinks necessary for this process. Why? Well, think several defendants facing separate trials, or a single person facing different allegations at separate trials. Information in the first case might affect jury in the second case. That the imposition or continuation of such an order can be challenged if there is no later stage of the same case, or no case pending or imminent to protect from publicity, and or if the purpose for which the order was made is to ban publication of someone's identity to protect their or someone else's welfare or reputation, rather than to protect the administration of justice. That's a long one, isn't it? So not much is found. I didn't find much here, but if something comes about challenging a court-ordered restriction mention that the Judicial College guidelines on reporting restrictions may pick up a mark or two. All right, let's hope that didn't come up. Okay, we need to know the danger of reporting during a Crown Court trial, even if no Section 4.2 order is made, proceedings heard in the absence of a jury. So even if an order has not been made, if there's a risk of reporting certain details which seriously prejudice other court proceedings, these should not be published. Remember, the Section 4 defence is subject to good faith. And if there's no jury, that is not open court. So those items should not be published. 3.6. The general danger of contempt as regards failure to obey court orders, injunctions which could lead to a fine or jail sentence. So contempt is 2 years and or an unlimited fine. 3.7. That Section 9 of the 1981 Act bans audio recording devices being taken into courts, including coroners' courts. And it bans such devices being used without permission in court, and bans any such recorded material being broadcast or played to any section of the public, and why this law exists. That is, its aims and purposes. So basically prevents witnesses' testimony being broadcast. McNay suggests that a criminal's associates could use this to intimidate a witness. That the criminal procedure rules allow a criminal court to grant permission for such a device to be used in court for note-taking, including by journalists, but that a practice direction indicates that there must be a reasonable need for such use. That is in Rule 6.9 of the Criminal Procedures Rules. 3.8. The scope of the ban in the Criminal Justice Act 1925 on photography, videoing, filming, portrait making, sketching in and around court, including in coroners' courts, and on publication of such material. So Section 41 makes it illegal to take or try a photo film, take or try to take a photo or film, make or try to make, with views of publication, a portrait or sketch, publish such a photo, film or sketch. Note this is any person, it's not just restricted to press. It includes within the court precinct and any person entering, leaving. There is an issue with understanding what exactly a court precinct is, but we'll come on to that, I think. Oh yes, photos on public pavements where it has become customary practice, such as the High Court in London, classic example, it is unlikely that a court will object. For a breach, you're looking at fines of up to £1,000 unless it's considered contempt of court. Difficulties of interpretation of precincts, I touched on that. Okay, and how the media legally publish portraits, sketches of court proceedings. So, certainly in the case of sketches, artists attend, they create, and then they go away and create images from memory. There is no objection to sketching in a courthouse press room, which is actually on the precinct. The risk of punishment under the common law of contempt as regard to photography, videoing, filming in and around. So we've covered that. And the need for permission to photograph film when juries visit locations such as crime scenes or in inquests, accident sites, because in such visits the court has moved to that location, and therefore the 1925 Act's restrictions and the common law of contempt apply there. So basically you cannot film without the court's permission. The judge coroner may allow this as long as no juror can be identified. 3.9. The power under Section 11 of the Contempt of Court Act 1981 to permanently ban publication of a name or matter in media reports of cases. A court can ban the publication of a name or of information in connection with the proceedings as long as it has first allowed that information to be withheld from the public. Typical usage of Section 11 and case law as stated here defining its scope. The ruling in Attorney General versus Leveller Magazine Limited that this power should only be used to prevent publicity which would frustrate or render impracticable the administration of justice. frustrate or render impracticable, that might be better, the administration of justice. So, quite a lot here, but Section 11 is used to protect against blackmail, protect commercially sensitive information, secret processes, protect national security, state secrets, or protect a person from the risk of harm. So AG versus Leveler magazine in 1979. Departure from the open justice rule was only justified, this is comments from Lord Diplock, where the nature or circumstances of the particular proceedings are such that the application of the general rule in its entirety would frustrate or render impracticable the administration of justice, or would damage some other public interest for whose protection Parliament has made some statutory derogation from the rule. We also have R versus Newtown Abbey Magistrates Court in Belfast, or again Belfast Telegraph newspapers in 1997. It's related to above. The High Court in Northern Ireland observed the words "some of a public interest" was in relation to the protection of the public interest in the administration of justice, not the private welfare of those caught up in that administration. This was on the back of refusing to grant a Section 11 anonymity, with the defendant's lawyer arguing that their client was likely to be attacked if his community became aware of the charges in light of similar instances for others facing similar allegations. Other cases in respect of names, matters already mentioned in open court, including R versus Arundel, Justices XP, Westminster Press. So in R versus Arundel, Justices and Westminster Press, a Section 11 order granted by magistrates was granted by magistrates. High Court in judicial review ruled that the magistrates had no power to make the order, as the defendant's details had previously been given in public when the clerk routinely checked the information with the defendant in the first hearing. So yeah, if details before, you can then withhold them. That the imposition or continuation of such anonymity can be challenged too on the basis that Section 11 is not to protect the comfort and feelings of defendants, as R versus Everton Justice McDonough showed, or that as regards a claimed risk of defendants or witnesses being attacked. Case law, e.g. R Officer L, says there must be a real and immediate risk established by objective evidence to justify the provision of Section 11 anonymity. Got anonymity right there. So in R versus Evesham Justices McDonough, the magistrates agreed defendant's address should not be given because he feared harassment by his ex-wife, and that was made under Section 11. A judicial review quashed the order, with Lord Justice Watkins saying it is well established practice that, save for a justifiable reason, defendant's address has to be given publicly in court, and harassment from his ex-wife was deemed clearly not justifiable. RE Officer L in the House of Lords, 2007, Lord Carswell is, in my opinion, clear that the criterion is and should be one that is not readily satisfied. In other words, the threshold is high. Okay, so on to the next bit. And or that a ground of challenge can be that if anonymity is granted to a defendant or a ban imposed on publication of his or her address, the public may wrongly think someone else is the defendant. I think that's as is. The danger of jigsaw identification if Section 11 anonymity applies. And there's a footnote here. As regards each mention of jigsaw identification in the subject to be studied and examined, content, a candidate will be expected to know that what the term means, and that in coverage of a particular case, rival media organisations may need to avoid jigsaw identification to adopt the same approach as regards to what detail is published. So jigsaw identification is when two or more publishers cover the same case, but if each report has a little bit different detail, the combination of them might mean the anonymity is lost. Hence why you should match up with other agencies and make sure your information kind of fits together. Doesn't provide details of who someone is who shouldn't be known. Okay, I think that's it for section 3. Oh, no, there's more. There's a lot. So 3.10. you need to know the power of criminal courts under Section 46 of the Youth Justice and Criminal Evidence Act 1999 to make an order that no publication should identify a specified adult, aged 18 or over, during their lifetime as being a witness in those proceedings. That the court can do this if satisfied that the witness is in fear or distress about such identification, and if the court is satisfied that the quality of her evidence or level of cooperation will be diminished unless there is this anonymity provision, and that the normal scope of such restriction is that no identifying detail must be published in this context, and what the section says as regards scope about detail which in particular should not be published if likely to identify the person. Section 46 specifically lists these items: the witness's name, their address, the identity of any educational establishment they attend or attends, the identity of any place of work, and any still or moving picture of them. This comes up a lot. That the Act says a ground for challenging the imposition or continuation of such an order, or for arguing the relaxation of its scope, is that it imposes a substantial and unreasonable restriction on the reporting of this case, and that it is in the public interest to remove or relax the restriction. So from my notes, the journalist should follow the Rule 6 procedure in the Criminal Procedures Rule. Home Office explanatory notes to the 1999 Act state, neither fear nor distress is seen as covering a disinclination to give evidence on account of simple embarrassment. Brilliant. That another ground which could be argued in challenge is that the restriction would not or does not serve much purpose. Challenge arguments which can be made about why a criterion, see above, for imposing the order may not apply. One of the things that McNay has was if the defendant knows the witness, for example. It also mentions the danger of jigsaw identification if Section 46 applies, so we've covered that, so that will come up a lot. That such person can give written consent to be identified in the media report of such a court case, and that circumstances which would make such consent invalid. We'll come back to that one. I think I picked that one up in a separate section, because that comes up again as well. 3.11, the protection in Section 20D of the Juries Act 1974 of the confidentiality of jury deliberations in civil and criminal cases, and the protection in the Commoners and Justice Act 2009 of the confidentiality of inquest jury deliberations. So just remember those. Easier. 3.12, the general permission granted by criminal practice directions for journalists to use computers or mobile phones in court to report cases contemporaneously by means of live text-based communications, which includes emails, texts, and tweets, provided the court has not banned such use in a particular case, and that such use is silent and unobtrusive, and that the permission does not apply to any other use of such devices in court. So since 2011, journalists and legal commentators have not needed to seek the court's permission, and this is now set out in the Criminal Practice Directions 6C.1 to 3, 6C.6, 6C.8, and 6C.11 to 14. And as touched on, devices must be silent and unobtrusive. There was, in fact, recent court case I went to, there was 3 guys furiously typing away on their keyboards. So that's part 3. I'm going to pause before we go into part 4.